How many in the audience?
The virtual audience, important everyone, we're quiet in the room now, we're gonna get the hearing underway. If you have the device open, please turn off the sound and put it on mute. Thank you.
Morning, everyone. My name is Bill Bergman, and I will be chairing this meeting of the Zoning Board of Adjustment. With me is our Vice Chair, Tanetta Graham,
Present, Mr. Chairman.
Board Secretary Cheryl L. Gaston,
Present, Mr. Chairman.
Board Member Michael Johns,
Present, Mr. Chairman.
and our Board Member Ryan McAdams.
Present, Mr. Chairman.
Also present is our attorney, Hillary Emerson, our ZBA Director, Ian Haggerty, and our Board Administrator, Lakeisha Dandy. This hearing is being recorded and will be posted on the ZBA website. By participating, you agree to be recorded. This is an in-person meeting with remote participation, whether in person or on Zoom. If you are called to speak, please state your name and spell it, and then wait to be sworn in. After that, each time you testify, you must start with stating your name. To enter an appearance, indicate the property address on your Zoom webinar. Speak with a staff member. Call the ZBA office by the close of business tomorrow. Call 215-686-2429 and provide your name, your email, and the address of the property in question. Remote participation. Raise your virtual hand when directed so that we can call upon you. When we call upon you, you must click the Join as a Panelist button. Use your Q&A for procedural issues. Please do not mention anything to do with the case. If you are joining by phone, press *9 to raise your hand and *6 to unmute for in-person participation. In testifying, get close to the microphone so that all in attendance and our court reporter can hear you. No talking, eating, or drinking. Aggressive behavior will not be tolerated. In an emergency, follow staff's directions. The main exit is the rear doors. The nearest stairwell is to the left. If we evacuate, go to Love Park across R Street. Please remain there and so that we can account for you. So let's look at our schedule for today. Number one, MI 2025-000-438, 4701 to 11 Edmund Street. We also have an interpreter for this case. Good morning. We'll be with you in 1 minute, okay?
Good morning. My name is Stephen Abain, last name spelled Aubain, interpreter ID YM288. I'll be the Spanish interpreter.
Do you swear or affirm that you will interpret accurately, completely, and impartially from English to Spanish, from Spanish to English?
Yes, I do.
All right. Would you please call our witness is Angela Perez Garcia?
Así que si Ángela Pérez García puede levantar la mano o prender su micrófono.
And then asked her, does she, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
¿Usted jura y afirma decir la verdad, toda la verdad, nada más que la verdad?
Sí.
Right.
Yes.
Could you please tell the appellant that we need updated documents to go on with this case, and that we're going to have to continue it today, and that our staff will work with her for the next case, those that she's prepared. Could you please say that?
Así que nosotros necesitamos documentos actualizados que vayan con su caso. Así que nosotros vamos a continuar su caso el día de hoy y nuestros trabajadores van a trabajar con usted para que la próxima vez tenga todo lo que necesita.
Okay.
Okay, and could you tell her this case is going to be continued until 8/5/26 at 2 p.m.?
Así que este caso va a ser continuado hasta 8/5 de 2026 a las 2 de la tarde.
Okay.
Okay, thank you very
And-
much. Interpreter, thank you for,
And I'm sorry, it's going to be marked must be heard, Mr. Chair.
what is it?
Marked must be heard.
Oh, Mark must be heard on 8/5/26 at 2 p.m. Thank you.
Y
Please tell
marcado
her
como
that it must be heard the next time.
Así que ese caso se tiene que ver la próxima vez, así que eso va a ser en 8/5/2026 a las 2 de la tarde.
Okay, thank you.
And this is the interpreter speaking. Is there another case
No,
service?
no, there is not, and we want to thank you for your help.
All right, thank you for using this service.
Number 2, MI 2025-001 676 601 Devereaux Avenue. This case is continued to 8/5/26 at 2 p.m. and Mark must be heard. Number 6. Right with you. A lot of pages up here today. Okay. Okay, so number 6 is MI 2025-006 999 175 West Oxford Avenue. This case is continued until 8/5/26 at 2 p.m.
And
Right.
Mr. Chair, that should also be marked must be heard. Thank you.
We're going to mark that, must be heard too. Thank you. And then number 8, right? Number 8. MI 2025-001-070 5201 Old York Road. This case is continued to 10/6 at 9:30 a.m. Okay, any other requests for continuance?
Good morning, Chair. This is Jasmine. I will be your co-host for this morning's session. I see no hands at this time.
Okay, thank you. Number 3, MI 2025-003 858 510 to 28 South A Street. Carl Primavera is an attorney. Paul Bonney is also attorney, and Darren Steinberg is also an attorney. Mr. Steinberg, why don't you come up and I don't see Paul here. He might be coming in on. Okay, sure. And how about the city attorney? Okay,
Morning.
good morning.
For the record, Carl Primavera, the attorney of record for the applicants.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, let me just get my thing straight here. Sir, could you give us your name?
Yes, good morning. My name is Darren Steinberg, DARIN STEINBERG. I'm here on behalf of protestants Sean Sullivan, Cade Oda, husband and wife, as well as Jack Wassey and Elizabeth Kim, husband and wife.
All right. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Mr. Bonney?
Yes, good morning. My name is Paul Bonney, B-O-N-I. I'm here on behalf of the Lombard Muse Owners Association.
All right. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, so just a couple issues to start. Obviously, we have this important case, but we also have several other cases today. So we've given this case 50 minutes. What we intend to do is to get through the attorneys and possibly the board, but we will not be getting to the virtual audience or the audience in general. We're going to have to continue that. So what we want to do is have, that'll be continued to a different date. So I believe where we want to start is you'll go first, Carl, right? Paul will go next, and then council, you'll be third. Hopefully that we get all this in. But keep in mind, it's a total of 50 minutes. And council, you have anything else?
No, I just thank you all for coming out. I know, I'm sorry we're not going to be able to get to testimony today, but we will set a time for that and we'll have plenty of time to do that at another date. Thank you.
Okay, so we're going to get an update from the applicant.
Yes.
So Carl, could you please start?
Yes.
And
So
we
where
don't
left-
want to zero you in, but 10 to 15 minutes?
Yes, and I don't think I'll even need that. And we may move quickly enough that we may get to the complete record, but where we left last time, I finished my case. And Mr. Bonney reserved the right to protest if we hadn't finished an agreement with the Lombard Muse. Well, as you'll see in the record, we have reached an agreement with them, so he has no objection, so he will not be presenting any protestant testimony. In the meantime, based upon the agreement and further meetings, we have revised the plans, and you'll see in your record a revised refusal. It doesn't substantially change the refusals. So even though we've made the project smaller, we still have the same refusals at issue. So at our point right now, we have submitted into the record a legal memorandum. So, because we assumed we would not have time for legal argument at the end. So we have a written legal memorandum, the revised refusal. And with that, I think it's going to be for Mr. Bonney and then Mr. Steinberg to go ahead with their case. And again, I intend to be extremely limited in cross-examination with the hope that we can either complete the record today or hopefully have a very short session in, we'll call it a short period of time, because we've been at this for a long time, and I know the board has a tremendous amount of caseload, but we're trying to get to the end.
All right, thank you very much. Mr. Bonney?
Oh, thank you.
Hold, before you start,
Sorry, Mr. Primavera, did you just want to briefly explain the changes and so what's changed about the refusal since last time? And if there's anything, I wasn't sure if it's the same plans that you had presented last time, or are there any additional changes, just for the record, so we know what the
Yes,
scope is?
there are revised plans that were submitted to L&I and the revised refusal. We have officially eliminated 2 of the 3 residential units, the accessory residential units on the roof. We've lowered the project. We've made some other setback, adjustments, and we have the architect, Stuart Rosenberg, who can go in more detail, but we've modified the plan in a way that obviously was acceptable to the Lombard Muse Homeowners Association. But even with those adjustments and revisions, which we believe are substantial and material, we still have the same issues. And very briefly, the items of the refusal are: 1, we're expanding a non-conforming use. 2, we don't have the ability, since there's an existing structure, so we don't have required open space. We're not detached, we are attached. The access to the building, which it currently has and which it will have if approved, is from a primary street, and we don't have all the parking that would be required under the code. So they were the original refusals, and now even with our modified and reduced plans, they're still the refusals.
All right, thank you very much. Mr. Bonney?
Thank you, Mr. Chair, members of the board. I represent the Lombard Muse Owners Association. We submitted a letter of support a couple weeks ago. Looks like it's May 7. And, I saw the other night Mr. Steinberg took issue with our letter, so I just wanted to describe what we did and where we are right now, which is a position of support. So very briefly, Lombard Muse is a community of 35 homes adjacent to the subject property. More than a year ago, our association formed a task force to negotiate with the applicant to try and shape the design of the project, to try and obtain protections during construction, and to try and impose some limitations on the ongoing operations. And after extensive discussions, including meetings hosted by the RCO and meetings occurring in the office of the councilperson, a draft agreement was reached. And once we circulated it among the Muse, it was even further refined. A few weeks ago, on April 29th, the Lombard Muse Owners Association voted on that agreement after weeks of review and discussion, including about the fact that we would be providing a letter of support. The agreement was approved decisively, 22 in favor, 7 opposed, and 2 abstentions. And that's what I had reported in my letter of a few weeks ago. 4 members of the association did not attend, either in person or by proxy, and therefore they did not vote. And I believe that it's inaccurate or improper for Mr. Steinberg to try and count the 4 no-shows as abstentions. In any event, it doesn't matter because the outcome was so overwhelmingly in support of the agreement that we reached with the applicant. We do respect the right of the 2 Muse households opposing the project to express their views today. However, it is unfair to try and undermine the clear decision reached by the vast majority of the Muse. I'm available if there's any questions, but we want to thank all
Council,
stakeholders.
hold on. Hillary has a few
Yeah,
questions.
just a
Or
quick.
one question.
Yeah, just a quick question, Mr. Bonnie. I just wanted to confirm, because last time you had indicated that your client was challenging the refusal. You are no longer challenging the refusal. Is that correct?
That's correct.
All right, thank you.
Mr. Steinberg, could you please start your presentation?
Sure, thank you. Just a couple quick points on that. So I think the letter that we submitted stands on its own.
Yep.
And there's nothing in response to that. I do want to point out that my clients are the only unit owners in Lombard Muse that have party status. They're not the only ones in opposition. Just wanted to make that point. Real quickly, we listened to the testimony previously. We have 2 experts ready to testify virtually. I do want to do a quick cross-examination if I'm allowed, but basically what we want to try and establish here is that what is being proposed is not a school that has been pared down to its bare essentials as has been testified to previously. And also that the variances that you're being asked to consider doesn't match the full scope of the project, which we believe still includes religious assembly and things that are no longer in the refusal, but are yet clearly shown on the plan and in the development agreement that was entered into with Lombard Muse. And third, we would establish that the impacts go beyond that which you would expect in a permitted use in the RM1, and therefore they haven't met their burden for the variances. Just a real quick technical legal point. This is not a non-conforming use case. This involves a non-conforming structure in which they're asking for a variance for a use that isn't permitted. So I think that's an important distinction. There's nothing about this property that existed prior to the zoning code or anything like that. There's no non-conforming use here. They're trying to make a non-conforming structure, they're trying to get a use that's not permitted into a non-conforming structure. So I have 2 witnesses ready to testify and a quick cross-examination of the rabbi if I'd be able to.
Sure. Are we okay, Hill?
I defer to Mr. Primavera if he wants to recall his client for cross-examination.
Well, the understanding was we did have a whole first hearing, and unfortunately, Mrs. Steinberg wasn't here. So I would say he can ask questions of the board, and the board can ask questions of the rabbi if they would like, but we're not going to consent to any witness who testified before where there was the opportunity for to be crossed now.
Okay, why don't we start with who's your first expert witness?
That would be Jerome Skrzynkoski of Hawk Valley Associates. He's a land use and zoning expert.
Jerome?
Jerome will be coming in as a panelist.
Thank you. You can't see? You'll see it up there.
No, we're just the exhibits that we, that we already. I don't see a place
Jerome?
for my screen.
Can we promote Mr. Steinberg to a panelist if he's not a panelist already?
Oh, I'm
So
sorry.
he is on the panelist side.
I didn't
I'm
see
not
it.
sure if he's having technical difficulties.
Now I see him. Thank you.
No problem.
Jerome? Do we see Jerome?
Yes, Chair. Jerome has been promoted to panelist. I'm
Thank
not
you.
sure what's going on.
Jerome, can you hear us? You're unmuted. Mr. Steinberg, if he seems like he's having technical difficulties, could we move to your second witness and he can try to work through that in the interim?
Sure. My second witness is Lee Klein of Klein Traffic Consulting LLC. He's a traffic engineer.
Lee Klein has been promoted to panelist.
Morning.
Good morning. Could you please state your name and spell it for the stenographer?
Certainly. My name is Lee, middle initial D as in Daniel, Klein, Klein.
Right. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Counsel?
Thank you. Good morning, Mr. Klein. Are you a licensed professional engineer in Pennsylvania?
I am.
And are you also certified professional traffic operations engineer?
I am.
And for how long have you had those licenses?
Pennsylvania, I'll have to look on my wall here. I'm not sure how many years that's been, close to 20, and the national certification about 20 as well. And they're both in
And-
good standing.
And approximately how many traffic and parking studies have you prepared or reviewed in your career?
I have over 40 years of experience in traffic engineering and transportation planning, so I've done hundreds of traffic impact studies for offices, retail, institutional, such as private schools, public schools, daycare centers, and so forth.
And is your CV attached to our exhibit list?
I believe it is.
Right. And how many times have you testified in front of zoning boards, approximately?
Over 150 times throughout New Jersey. I've been accepted as an expert in traffic engineering, transportation planning, and parking analysis.
If it's okay, I'd like to offer him as an expert in traffic.
Mr. Primavera?
Yes, we would like to ask a question or two.
Sure.
Mr. Klein, have you previously testified before the Zoning Board of Adjustment of the City of Philadelphia?
I have not.
All right. And your office is in, we call it Northern New Jersey?
Correct.
And did you come into the property or see the property before issuing your report?
I have not.
And I saw your voluminous, extensive resume, which certainly shows competence in many areas. But if I counted correctly, your resume shows 40 municipalities where you've worked, all in New Jersey, 30 traffic studies, no mention of Philadelphia, and 4 expert testimony cases, no mention of Philadelphia. So is it a fair statement to say this is your first opportunity in testifying before the zoning board on a matter of Philadelphia zoning?
That's correct.
All right, so I would stipulate that he's a traffic engineer and he has experience, but I would object to calling him an expert in Philadelphia land use. We have our own zoning code we don't follow the municipality's planning code, and he's a novice, but I think that goes to the weight of his testimony in Philadelphia.
Right, okay.
Just a quick
Counselor-
rebuttal to that. His testimony is not about the zoning code per se, but about the report that was submitted by the applicant and those standards for traffic.
So.
So in that regard, he should.
So we're going to recognize him as a licensed engineer, and, he has done a lot of work outside of Philadelphia, but I'm not going to call an expert witness, okay?
Okay,
But you can start your testimony.
thank you. Mr. Klein, were you present in the room when this hearing first was heard back in March?
No, I was on Zoom.
But you listened to the testimony, correct?
I listened to the testimony. I believe it was March 4th.
And you've been provided and reviewed all the documents that were presented, including the applicant's traffic study?
That's correct.
Okay. And if you could just give us your assessment of the applicant's report and your observations overall as a traffic engineer.
Sure. There are about 5 or 6 points that I want to make about this application. The first point is in the traffic impact assessment that was performed by TPD, the applicant assumed, based on information provided by the client, that 70% of the students would arrive by non-vehicular method. They would either walk or take mass transit. I stipulate that the impact study has failed to explain or provide backup data for that. The school exists on Lombard Street. They could have done a count there to count the number of cars, number of students, the walking students, the number of cars that were dropped off, how many students in each car, to come up with that number. So they've assumed that number, and I don't believe that there's enough data to support that. So now they've got a frontage along their site that's about 112 feet wide along South 8th Street on the site that they're proposing. They're proposing a 12-foot wide driveway, so there's about 100 feet left, and that maximum of about 4 cars could queue up along their frontage to drop off and pick up students. And what my issue is with this is that there are only 4 parking spaces available for that. If there are more than 4 cars dropping off within the same minute or two, then traffic is going to queue up and back up out onto South 8th Street and could potentially block at least one travel lane on South 8th Street. I also noted that when I looked at street view around the area, there are times when the apartment building across the street, the Bradford Apartments, they have deliveries and mail trucks show up. And there's times when that left lane of southbound 8th Street would be blocked. So there could be times when South 8th Street could be blocked completely by either a vehicle stopped at the Bradford or vehicles queuing up beyond the 4 cars that the capacity for the drop-off has. The traffic impact study stated that there was no traffic impact for the development. The traffic impact study also mentioned that they studied the peak hour of the drop-off. And my contention is, based on my experience and my observations at other schools, private schools, public schools, that when there's a start time at the school, the drop-off period is typically 15 to maybe 20 minutes long. People concentrate in that 15 to 20 minute period to drop off their children. They don't need to drop them off extra early. They want to be able to get there, drop their kid off, and go on their way to wherever they have to go next. Also, I would say that the PM pickup time would actually be worse. In some of my observations of private schools and public schools where drop off and pickup occur by personal vehicles, those vehicles tend to arrive on the early side. So if school ends at, let's say, 2:30, the vehicles start to arrive at 2, so they get a good parking spot because they need to take their child to their next activity in the afternoon. So that will definitely be queuing up more than 4 vehicles for probably a good half hour to 40 minutes. And the traffic impact study did not address that. There's also the 230 seat auditorium in the property in the first floor, I believe, that is going to have some sort of events there. There's no mention of where people will park for those events. And again, if it's going to be 70% of the people are not going to drive, but 30% are going to drive, there's still a significant amount of traffic that could be generated by the 30% of the people that arrive to come to those facilities. I didn't see anything about garbage and recycling collection. Again, because of the narrowness of South 8th Street, and there is no ability for a garbage truck or even a delivery truck to pull into the site to be able to pick up garbage, recycling, and drop off, let's say, lunch, produce and things like that for meals. I also looked at the parking layout on the site plan. Sheet Z11, it has an amendment from the zoning board amendment number 2 revision date March 26, 2026. That drawing shows the 12-foot wide driveway. It also shows that the parking spaces in the site are only 8 feet 6 inches wide, which is typically less than a 9-foot wide standard parking space. They do provide 18-foot long parking spaces, but the drive aisle to be able to maneuver into those narrow parking spaces is only 18 feet 6 inches. So I would say that if they are able to maneuver, it's going to take a lot of maneuvers to get in and out of those spots. The parking spaces, I believe it's 7 and 8 that are closest to the wall, they don't have enough room to maneuver out to be able to make enough K-turns to be able to get out of the site or even to get into those parking spots. So I would say that they do not have 12 parking spots in that property. They need to get it down to probably 10 or even less. But because the drive aisle is so narrow, they may have to lose a whole row of parking. So they may get it down to maybe 6 parking spaces if they were to design it properly. So just to sum up, so 30% will drive, but there's no data to support that. They could have easily counted cars over at the Lombard facility, and the Lombard facility has parking off-site. You're not allowed to stop on Lombard Street. There's signs posted there. So cars do pull into the site, drop off the children, circulate around, and come back out. They could have easily counted the number of cars that are on site to drop off and pick up, but they did not. And I don't believe that the 4 spaces in front will be adequate. They also need to get the street department and the parking authority permission to be able to reserve those spots for particular times for drop off and pickup. I also think that the level of service is understated because they didn't concentrate the drop off and pickup and the arrival traffic and the departure traffic in that 15 to 20 minute period. They should have quadrupled, multiplied by 4, or multiplied the traffic generated by the site by at least 3 to show what it would be if we were analyzing 1 full hour. Also, again, the event space was not accounted for. How many events will there be? Will there be, if there's 230 people here, how many of them are going to drive? Where are they going to park? They didn't do a study of the area to see that, oh yeah, there's a parking garage that has availability in the evenings, and we've secured 40 parking spaces in that garage. They could have come up with a mitigation for that, but they did not. So that's my direct testimony.
And Mr. Klein, as part of your review and preparation for today, did you review the Philadelphia zoning code, in particular, the requirements for a variance?
No, I reviewed just the traffic impact study and the presentation material that was presented back in March and the site plans and so forth.
Okay, but are you familiar with the requirements for a variance as it relates to traffic and impact for a use variance?
I'm sorry, I would actually have to look that up.
Okay, I have no further.
Mr. Rivera?
Just a few. Mr. Klein, how many travel lanes are there on South 8th Street?
There's 2 travel lanes southbound and then the 1 parking lane on the right.
Okay. And you didn't do a traffic study. You did a critique of TPD's traffic study.
That's correct. In my experience, it's the applicant's burden to be able to show that something works. I'm just pointing out the faults in that report.
All right. So it's a criticism rather than an independent study that would otherwise satisfy the street department or PennDOT or New Jersey DOT.
I'm not sure I understand the question.
So what you submitted, you could submit to, any authority as a study. It's a critique based upon a review of somebody else's study.
That's correct. Yes.
All right. And with regard to the synagogue, which is nearby, which has been operating for many, many, many years, and the preschool there, do you recall the rabbi's testimony regarding how they have been able to manage that process successfully and without incident? And that's why they're so confident that the numbers will work out in favor of walk-ins for 8th Street?
Yes, but like I said in my testimony, that site has off-street parking. More than 4 cars can be accommodated, and more than 12 cars, I believe, would be accommodated. If they were to use that parking in the garage, the 12 spaces for drop-off pickup, in my opinion, that would not work. The dimensions are not correct. But if they're using the 4 parking spaces along South 8th Street, that's way undersized compared to what they have on Lombard. Plus Lombard, I believe they only have about 70 students. Here they're going to have 180 students. So it's going to be even worse in this location.
Did you talk to the city's Department of Streets regarding their review of the plans, the parking layouts, access, and the like?
I did not.
All right. And I would just say finally, with regard to this neighborhood, you didn't go there on purpose, but you are familiar with, obviously, this is a very dense urban neighborhood with multiple schools in the immediate vicinity of all types and persuasions?
Yes, I've looked at Google Street View, aerial photographs, and so forth. Yes.
All right. It's not like a strip market or a strip mall or some other facility in Piscataway or upstate New York, is it?
No, and I've done work in Jersey City and Hoboken, Newark. I've done work in urban areas, and I've done daycare centers and schools within urban areas, and we've got to provide enough drop-off capacity and pickup capacity so it doesn't impact the public street.
Right. And you said you were familiar generally with the zoning code, but are you familiar with the non-residential uses that are permitted by special exception in this district?
No, I just did a critique of the traffic impact assessment and the site plan.
Would you be surprised to know that that they include schools, religious institutions, hospitals, and the like in the RM1 district?
Objection, relevance. This is not a special exception case.
Well, the comment is that if we were able to satisfy the special exception criteria, then these uses would be by special exception, which is a common condition as a permitted use and not at all exceptional.
So,
But that assumes this is a detached building, which it's not.
sure. So I note your objection, but I'm going to allow the testimony.
So are you familiar with the special exceptions allowed in RM1 district where this property is located?
What my role was to review the site plan, to review the traffic impact assessment, to review the potential drop-off and pickup issues, and I came up with these criticisms based on what I observed, what I
Okay.
analyzed in their reports and site plans.
So the answer is no.
I mean, yeah, correct. That's correct. Yeah.
Thank you. I have nothing.
You want any follow-up?
I do not.
Or do you want to try your other?
I would love to. if you-
Jerome, am I right?
That's correct.
Jerome?
And if you can pronounce his last name. I'd
No,
appreciate
that's why I said Jerome.
Jerome has been promoted to panelist.
Thank you. And Counsel, just so you know, you have 10 minutes.
it. I know.
Okay?
Did you want to swear him in or?
Yeah, as soon as Jerome, I got to get him on the mic first. Jerome.
Yes.
Hi, Jerome, could you please state your name and spell it for the stenographer?
Yes, it's Jerome, Jerome, last name Sprinkowski, Skrinkoski.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Counsel?
Thank you. Mr. Skrinkowski, forgive me if I mispronounce that. What is your profession, please?
I'm a professional planner, planning consultant, zoning consultant, and community development consultant.
And are you a member of the American Institute of Certified Planners? And if so,
Yes,
how long?
Yes, I've been a member of the American Institute of Certified Planners for 25 years. I also have a total of 41 years of professional experience.
And is your CV attached to your report?
Yes.
And approximately how many times have you testified before zoning boards in Pennsylvania?
Close to 1,000, I would say.
Have you ever testified before this board?
No.
Do you think that precludes you from being an expert in this matter?
No.
I'd like to offer Mr. Skrinkowski as an expert in zoning and land use planning.
And
Counsel?
I would agree generally, but I would say that expertise does not follow through with County of the First Class, Philadelphia, which has its own home rule charter, its own zoning code, and its own unique issues.
So we'll accept him as an expert witness, but obviously not as an expert in Philadelphia, okay?
Okay, thank you. Mr. Skrinkowski, have you reviewed the original application, the original plans, the original notice of refusal, revised refusals, and were you also present at the last meeting virtually?
Yes.
And were you also provided a copy of the development and operations agreement that was entered into between the applicant and Lombard Muse?
Yes.
Okay. And did you listen to the testimony that was previously presented by the applicant?
Yes.
And did you review the Philadelphia zoning code as part of your presentation for this matter?
Yes.
And did you prepare a written land use and zoning report for this matter?
Yes.
Okay. Are you familiar with the definition of an educational facility under the Philadelphia zoning code?
Yes, I am.
And what is your understanding of what that definition is?
The public or private school at the primary, elementary, junior high, and high school level that provides basic education.
Okay. You're aware that the current notice of refusal no longer has reference to religious assembly, correct?
That's my understanding.
But the original notice of refusal did, is that right?
Yes.
And are you familiar with the definition of that religious assembly under the zoning code?
Yes, and I think I might have referenced it, but if I did not, it's religious services involving public assembly that customarily occur in synagogues, temples, mosques, churches, and other facilities used for religious worship.
Okay. The development agreement that was entered into with the applicant and Lombard Muse, that permits weddings, correct?
No, it permits. It's my understanding that it would permit weddings. Yes.
And bar and bat mitzvahs?
Yes.
And an annual week-long celebration of Sukkot,
Yes.
as well as indoor celebrations of all Jewish holidays with the right to serve liquor?
That's my understanding. Yes.
And in your professional opinion as a land use and zoning expert, are those activities typical or customary for a K through 8 school?
No, because what the applicant is asking for was to establish a educational use, and those would be subordinate uses that would not be necessarily permitted as part of a general or as an educational use.
So even if they were to be considered subordinate, would you think that would you consider them to be necessary to have a school?
No.
Okay. Are you familiar with what a non-conforming use is under the Philadelphia zoning code?
Yes.
And if I said to you that it was a use lawfully established that does not comply with current zoning regulations, is that what your understanding is?
That would be correct.
Does this application deal with a non-conforming structure?
The case would apply to a non-conforming structure only if the use that is proposed would require it to be detached.
But we're not here talking about a non-conforming use, correct?
Correct.
Okay. Does an educational facility require a penthouse to operate?
No.
Does an educational facility require a roof deck to operate?
No.
In your professional opinion, having looked at the plans and heard the testimony, if that penthouse was eliminated, would the vertical expansion above the 38-foot height limit be necessary?
It more than likely would not be necessary if that would be eliminated. There may be other rooftop apparatus or equipment, but that may also would not be considered a occupied use.
And in your professional opinion, has the applicant pared down this project to the minimum relief necessary to operate a school?
No, the relief sought is materially greater than what a school would generally require.
I have no further questions.
So we have 3 minutes left, and I don't want to shorten your cross, so we're going to bring that back, that cross. But counsel, could you please give me an idea of what the rest, I'm not pushing you, the rest of your case, what's it look like? So then when we plan for the next date, we'll know what we need to do.
I just want to call my one client witness. He'll speak on behalf of the other three. That should take 5 or 6 minutes. And then I'd like to reserve time for anything that comes up after we on cross.
All right, so we're going to continue this case. We'll start with cross of this person the next time, and we're going to continue until 7/28/26 at 9:30 a.m. And I want to apologize to the people in the room that we couldn't get you today. This is a complicated case, and we want to make sure everybody has their testimony. Okay?
Thank you.
Thank you both, and I appreciate it.
Thank you.
So number 4, right? We'll wait till they.
I saw. You said that little girl was so serious there, like, hey, get down.
Well, we're not. I mean, I'm gonna take written up. That's if we get through it. Mr. Knockham sit in their room?
I have Alex Goldberg with his hand up.
Oh, is Mr. Goldberg here, or is he in the?
He's in a virtual audience. Do you want me to
Okay.
put him to panelists?
All right, sure. Why don't you start bringing them on?
Thank you.
Morning, Mr. Chairman.
As soon as I get people out of the room, we'll have you on. Boy, everybody left. Nobody left. Alex, why don't you state your name and spell for the stenographer?
Alex Goldberg, ALEX GOLDBERG.
Right. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Alex, this is a resumptive hearing, and we're going to take an update from you, questions from the board, public testimony, and also a planning commission. If possible, could you just give us a quick update of the case and then start your presentation?
Sure. So should I do that before I share my screen, or?
You could do it either way you want.
Okay. All right. I'm gonna share my screen while I do it. So We had our previous hearing on March 4th. We had a positive meeting with the RCO, but there were some requests that they made of my client with regard to improvements to the property. We're seeking to legalize an existing triplex. The zoning changed here 8 years after my client bought the property as a legal triplex. And he had failed to renew the rental licenses, so we're going through this process to reestablish the legal status of the property. It took my client some time to do those repairs because of the large snow that we had, but they were done. Here's the letter stating that the RCO's position has officially changed to non-opposition, and I will show you the photos of the work, of the new posting photo, and then the photos of the work. So this was the before and after. They wanted us to repair and replace these doors right here, and also this sort of trash alcove, which is what my client did. So that work has been done. We were in touch with the RCO the whole time, and now they're in non-opposition. That's about it as far as an update that I have for you.
Questions from the board? Questions or comments from our attorney?
Not at this time, Mr. Chair.
Questions or comments from the virtual audience?
I see no hands at this time, Chair.
Planning Commission.
Nate Dorfman, Planning Commission staff. There is no change to the Planning Commission's.
Hold on. Just spell your name for the stenographer.
Sure.
That's not a problem, but go ahead.
Nate Dorfman, NateDorfman.
Right. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes.
Please proceed, sir.
Nate Dorfman, Planning Commission staff. There is no change to the Planning Commission's testimony.
Thank you very much. MI 2025-006-651, 4416 Locust Street. I vote yes.
Michael Johns, my vote is yes.
Cheryl Gaston, my vote is yes.
Tanetta Graham, my vote is yes.
Ryan McAdams, my vote is yes.
Thank you.
Thank you, counsel. Number 5, MI 2025-006-975, 2015 Frankfurt Avenue. Rachel Pritzker is the attorney. Okay, so why don't we, sure, take a seat. Rachel?
Yes,
Rachel, could you please state your name and spell it for the stenographer?
sure. Rachel, Rachael Pritzker, Pritzker.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Counsel,
Jordan Rand for Protestant Dorothy Carell.
could you spell your name for the stenographer?
Yes, Jordan, Jordan, Rand, Rand.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do, sir.
Rachel, could you identify your client in relationship to the property?
Yes. My client is Yuri Tomoshak on behalf of XL2 LLC, who's the owner of the property. I also want to make the board aware, I wasn't aware that there was an attorney in opposition to this matter and have not been presented with anything or had an opportunity to discuss anything with them as well.
So I understand that Ms. Pritzker has been in touch with my partner, Frank Carell, for the past several months. I am not going to put on any evidence, physical evidence, so I have not submitted any documents. I am going to present my client, Ms. Carell, and I would like the opportunity to cross-examine the applicant's witnesses.
Rachel, do you want to go on or do you want to continue this?
I would suggest a continuance just because, again, my client was not informed. I was not informed that there would be any sort of cross or anything from Mr. Rand. So I just don't want to waste the board's time.
Counsel?
With this organized hearing.
Our counsel.
If the board wishes to continue this matter, it may. We were not aware that there would be a protestant represented by counsel today.
Okay, so 2015 Frankfurt Avenue, case is continued until 8/5/26 at 2 p.m.
Thank you, board. Appreciate it.
Sure.
Thank you.
Right with you. Okay, so we'll do the first one first, then we'll add the other two, correct? Okay, so number 9, MI 2026-002-034, 4723 Shelbourne Street. Verna Anastasio is the attorney. Meredith Furliger is attorney for the, I guess, the appellant, and Leonard Reuter is the attorney for the city. Why don't we have, Vern, why don't you come up first? Oh, we'll swear them all in.
I was going to say, I believe Mr. Cook will be presenting this
Okay,
matter.
sure.
Thank you.
Mr. Cook.
Good morning, Mr. Chairman.
Good morning, counsel. Could you please state your name and spell it for the stenographer?
Harry Cook, HARRYCOOK.
Right. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do, sir.
Right. Meredith, are you out there?
I am
Okay. Could you state your name and spell it for the stenographer?
Meredith Furliger, Ferleger, and I'm here on behalf of the property owner, permit holder V&V Holdings LLC.
Leonard, can I swear you in? No.
Good morning. May it please the board, Leonard F. Reuter, REUTER for the city of Philadelphia.
For both of you, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
I do.
Mr. Cook, why don't we start with you? I understand you may be withdrawing this.
Oh, no, we're not withdrawing there were a set of consolidated appeals, one of which is moot on a
That's what I'm
permit that
talking
was
about.
issued.
So the one I called is number 9, and that's the one we understood you were going to.
This is the permit for the lot consolidation only, and then we'll
Yes,
call the
that
other
is
two.
that is correct. We are
Okay.
withdrawing that particular appeal. We have 2 compendium appeals, one of which is irrelevant.
Both councils obviously are okay with this.
Yes, and for the city, we'll apologize that there was some issues with why that happened. So that's why we worked it out.
Okay. Meredith?
Agreed.
Okay, all right, so MI 2029-002-034, 4743 Shelbourne, that case is dismissed. Next-
Withdrawn.
Mr. Chairman,
Withdrawn,
I
I'm
believe
sorry.
it's Sheldon.
Okay, Sheldon, okay.
Yeah.
So number 10, MI 2026-002-732, 4723 Sheldon. And number 11 is MI 2024-002-975, 4723 Sheldon. There are 2 cases we're going to hear, and both L&I issues, right? Okay. Do you want to start, Harry?
Yeah, thank you, Mr. Chair, members of the board. We have stipulated to the documents in question for this. The record includes the stamped subdivision plan, the legal descriptions, the zoning site plan, zoning permit ending in 03252 that creates lot T1 uses, and zoning plan 003245 that creates lot T2 uses. The crux of this appeal will be related to the off-street parking on ZP 2026-003252. The other property is brought in as compendium because they are attached, and that is relevant to the RSA 5 district parking requirements. And perhaps Mr. Reuter would chime in on that, and Ms. Furliger.
I'm not sure what I'm being asked to chime in on, but
That the stipulation exists as it relates to the documents
yes,
that
there is
form
a,
the
the
record.
stipulation exists with respect to yes, both the zoning permits, the permit application materials, which really just consist of a site plan and the lot line relocation plan. Again, just I guess for the record, the actual lot line relocation permits also part of the record, although Mr. Cook had already indicated that the appeal of that is withdrawn. So yeah, the two new construction permits, it was really just one site plan for both, and then of course the one lot line relocation for both. So we've stipulated to the authenticity of those to obviate the need for anybody to bring in a plans examiner just to certify that those documents.
And the references to
Do
any
you
of
say
the
Meredith was supposed to respond to this
yes.
too? Meredith?
I'm in agreement with the city's position on that as well.
Okay.
And Mr. Chair, members of the board, any reference to the documents will really be just in passing. This is primarily a legal argument. I'm just going to take about 7 to 8 minutes to make a presentation of oral argument, and then we'll take it from there. So, as discussed, I'm representing Tamara Crumlish. She's a neighboring property owner directly affected by the two zoning permits that we've just discussed. The only issue before this board today is whether L&I correctly determined that the off-street parking shown on the approved plans and approved for in ZP-2026-0035, 3252 is allowed by right under the zoning code, and respectfully, we submit that it is not. The department believes that the pre-existing non-conforming off-street parking use from the old lot is evidenced by the garage that is there on the plans and marked for demolition, can simply be carried over to the newly created lot, which we're referring to as T1. That is the lot that is closest and adjacent to and contiguous with my client's property. In many instances, pre-existing
Hey, Harry, just for a point of information, could you show this? Is there anything you have? that
Absolutely.
we
I can
look at
bring
this
that
while you're
up.
talking?
No problem. Let me share screen. Okay. Okay. So just for reference purposes, this is the current condition. This was the subdivision plan. You have this lot here and this portion here. This area is the area in question that has the garage to be demolished and replaced with a single family home with off-street parking. This is my client's property. Here's a good rendition of what it's going to look like. The two new properties. This is T2. Oh, I mean, excuse me, T1. This is the one we're talking about. This is the property that includes off-street parking and a new 38-foot build for a single family home. Okay. And again, this is the relevant zoning permit, okay, that includes off-street parking. So that's basically the extent of the true references to the actual record there. I'll just leave that up so you can see what we're talking about as I continue. So, as I was saying, in many instances, pre-existing non-conforming uses may carry over. That's why we have, affidavits of continuous use, etc. But here, the zoning code expressly prohibits this type of carryover for parking for new developments such as this. And I'll walk the board through the code provisions. The key provision is subsection 14-3059. It's a grandfather provision that governs non-conforming parking or site improvements, and it states in relevant part, where the amount, design, or location of off-street parking or site improvements does not meet the requirements of the zoning code, the nonconformity may remain and be used notwithstanding those nonconformities. But here is the essential part. However, all provisions of 14-800 parking and loading shall apply to the entire lot for any development or changes to structures or uses on the lot. So again, however is important, it creates a clear limitation. The first sentence, first portion of the provision gives limited grandfather protection when nothing changes. But as soon as there's a development or any change of structures or any changes of uses on the lot, the full requirements of the parking portion of the code, 14-800, must be followed. And only one of those enumerated elements must be met for the requirement to apply the new those zoning provisions to the project. Here, we have all three of those conditions met. First, it's a new development. The code defines development in 14-203-94B as the erection or relocation of a structure or an alteration to an existing structure that results in a change of gross floor area. The project clearly meets that definition. The applicant is building two entirely new single-family homes on a newly subdivided lot and demolishing all existing structures, including the garage. This is a development. Chapter 14-800 applies. Second, it involves changes to structures. The existing garage is clearly labeled to be demolished on the plans and on the approved site plan. Changes to structures. Again, 14-800 applies. Third, it also involves changes to uses on the lot. The code itself defines what an accessory use is. This is the use that is being attempted to carry over. In subsection 14-203, an accessory use is defined in relevant part as a use that is subordinate to and on the same lot as a principal use on a lot and customarily incidental to the principal use. Before the subdivision, any off-street parking at the garage was accessory parking. It was subordinate to the principal residential use on the original lot, which included a single-family home as its primary use. However, this subdivision bifurcates and separates those uses. In creating T1 as a new standalone lot, the garage, which is still standing, has no principal habitable structure, no single-family home yet to serve as a principal use. At this point, the off-street parking and garage are a principal structure and principal use on T1. This is a change of use. And now the current applicant seeks to recharacterize that same off-street parking, at least the department does, as accessory again to the proposed new home still yet to be built on a brand new lot. This again is another change of use. So we've had two changes of use, whether it's permitted or not. Under the code, chapter 14-800 applies. All three conditions of subsection 14-305(9) are satisfied. Development, changes to structure, and changes to use. So again, the full rules of 14-800 should apply with no exceptions. An L&I examiner has no discretion to disregard the plain language and meaning of this grandfather provision and its exceptions. The examiner's hands were tied, and he or she should have applied the rules of accessory parking here. And what are those rules? These rules are found at subsection 14-8031C.1. In the RSA 5 district, the code states, Accessory parking for any single-family, two-family, or multifamily use in an attached or semi-attached building, which is what we have here and why the T2 parcel is included, unless it can be, is prohibited unless it can be accessed from a shared driveway, alley, or rear street on which no on-street parking is permitted on the side of the rear street directly abutting the lot. And it also speaks to width requirements of that shared driveway. You can look at the approved plans, legal descriptions you have before you. There is no shared driveway of any width, no alley, no qualifying rear street. Because these are newly created lots from a subdivision and the existing garage is being demolished, there is nothing left to grandfather, nothing to carry over. This is a clean slate. And this principle of carrying over uses to newly created lots was just confirmed in re Appeal of Shell and Old Richmond Civic Association. In that case, the court held that a newly created lot must comply strictly with the current by right standards. There's no stacking or carrying forward of prior uses without meeting variance requirements. So, members of the board, Mr. Chairman, Madam Vice Chair, for all these reasons, LNI's approval of all-street parking is inconsistent with the plain language of the zoning code. We respectfully ask the board to reverse the department's decision and require the applicant to seek a variance if they wish to proceed with parking. And this would also serve to clarify for many of us who have put in very similar applications and have received disparate results in the past. And with that, I will be submitting my oral argument for the record as well in writing. Thank you.
Thank you very much. Mr. Reuter.
Thank you. The city's position here, well, first of all, I think we don't disagree with Mr. Cook's retelling of the code and what the code requirements are, but it's been the city's position here in this case that, you once had a single property that had a house and next to it was a standalone garage. And then that property there was a lot line relocation, which recently happened that we've all discussed. And as a result of the lot line, as a result of the lot line relocation, the garage that had been providing accessory parking to the house was now separated from the house. As part of the same project, applications were submitted. In fact, let me back up a second. Initially, the permit application was submitted to, in fact, do the lot line adjustment and the new construction, and then that was divided up into separate stages. So, but it's still part of the same project. The existing house was coming down, the garage is coming down, 2 new houses were being erected, and the house on the right, which I believe, as Mr. Cook identified as T1, for some reason, OPA had not yet issued placeholder street addresses yet for this. So they're both technically 4723 Sheldon, but one's T1, the other's T2. So this is T1. Thank you. And that will be a house, but also will have accessory parking at the property. So it's the city's position that this does not involve a case of a non-conforming structure. You heard a little bit about that earlier this morning. This is not a non-conforming structure case. I mean, the garage probably would have been a non-conforming structure in some respects, but it is really the non-conforming use of accessory parking. So the non-conforming use of accessory parking is continuing, and it will be continuing with this new construction. And it's kind of a side issue, but it was really, for the plans examiner, I think the only question that arose, and we can see that in some of the documents, was the treatment of the curb cut. And the city's position with curb cuts is, if the curb cut serves parking and the parking is okay, the existing curb cut's okay. So the city made a determination that the curb cut was okay. So basically, it's the city's position that yes, the parking restrictions in 14,800 typically do apply and would apply, but in this case, that use of that previously non-conforming accessory parking for this property, it being RSA 5, I guess, or the designation that doesn't permit parking except from a rear street or side street. This doesn't apply in this case because we have existing non-conforming accessory parking that's accessed from the front from a curb cut that itself is okay from the front, been there for decades. That's continuing. In fact, it's actually a little bit smaller than it previously had been. And therefore, we approved the permit. To the extent that there is some ambiguity that might be presented from the language that was quoted from 14800 and the language in the code that governs non-conforming uses, and also non-conforming accessory uses, the city believes that any ambiguity would need to inure to the least restrictive use of the property, which again, in this case, would also have resulted in the approval of the permit. So that's basically the city's position. It's a non-accessory. It is accessory parking that is an existing nonconformity because of the access, and that's continuing. So it's literally the same. I mean, again, if you look at the before and after pictures, you've got a garage there now. There's going to be a garage there later, and if anything, it's a little bit smaller.
Okay, thank you.
If I may rebut.
Well, but why don't we do this first? I'm going to see if Meredith has anything to add, and then you could rebut. Okay, both of them, all right? Meredith?
Thank you, Mr. Chairman. I just have a couple of maybe points of clarification, or just for purposes of the record, just a couple of additional points to make here. So first of all, just in terms of historical information that is of record with the city, the garage itself that is in question was permitted originally in 1955. The permit number in L&I system for that permit is 91010B. So that garage was actually permitted in L&I system. This isn't a situation where, you know, it's ambiguous in terms of the historical information that led to the legality of the garage and the parking in this location. Second of all, as the board well knows, the zoning code grants L&I full authority for final action regarding zoning permits, and that's codified at 143015. And furthermore, under the Home Rule Charter, L&I has specific powers that they have authority to exercise in their duties for issuing permits. And in particular, 14103H states that L&I is authorized to promulgate such regulations as are necessary and appropriate to implement the provisions of the zoning code. And in this case, we actually have one of the probably rare circumstances where L&I determined that there is enough ambiguity in the code that has existed on this exact question over the course of many years. They did, in fact, issue a fact sheet. I believe that I can bring it up on the screen, but there is a number at the bottom. It's PZ006 FAQ. At the top, it says, my property has an existing non-compliant curb cut. I'll bring this up just so you can see what I'm looking at. My property has an existing non-compliant curb cut. Can I reuse that curb cut when developing my lot? And this fact sheet seeks to answer that exact question that the board is being tasked with answering today. And ultimately, as you can see here, L&I goes through a very short analysis that basically says, if the curb cut legally exists on the property, it is permitted to remain regardless of whether it is compliant with the current base zoning district or overlay requirements. So this board is often presented with appeals against L&I where there are certain ambiguities in the code, or there's some question as to whether the examiner applied the code correctly. And here we have an actual fact sheet that the department in its authority issued for applicants to be able to reference when these types of situations arise. And because this garage itself was actually legally permitted, it is clearly of record, we would submit no ambiguity whatsoever as to whether or not only the curb cut could remain, but the legally non-conforming garage and accessory parking access would also continue to remain. And just in terms of a final point relative to the lot line change, although we might agree with the appellant's argument if this parking were being moved to the other house where it never existed, in this case, the parking is remaining and the garage is remaining effectively on the same lot that it had existed on historically. So by cutting the lot in half to develop 2 single-family homes, the parking is not moving from its original location and would therefore continue to comply with even general nonconformity rules in terms of reducing impact and essentially not creating any additional impact based on that longstanding nonconforming condition. So just again, in summary, we believe that L&I has full authority to promulgate their own regulations. They did so in exactly this type of case, and we believe that this fact sheet would essentially, clearly answer the question as to whether or not this was legally approved by the department.
Thank you. Harry, you don't want to respond, you said?
Sure. I'm going to start with response to Meredith. The code language in 14-3059 is explicit. And that is a legislative intent of City Council. And while L&I is free to come up with policy and create FAQs, they can't contradict the plain language of the code and what applicant is asking you to do and what Solicitor Reuter is asking you to do on behalf of the department is to disregard that portion of the code. That FAQ is very specific about pre-existing curb cuts. It doesn't speak to use. If the code wanted special dispensation for use, it would have said so in that section, 14-3059. In fact, it says the exact opposite there. One, going back to Mr. Reuter speaking to, this being a subdivided lot, we're just going to put the new use, the existing use over here, we're going to carry it over. Well, I mentioned the case Shell before. That was a case that Vernon and I brought to this board, seeking to consolidate 3 parcels and stack by right uses to have 3 by right units on there. And it was through the variance process. A lot of the things about prior use, about look and feel of the block, etc., those are all criteria for variance. You could come back to the board and get a variance here. But in Shell, the court specifically said that when you create a new lot, you are bound by the zoning code for that new lot. And any changes, you're starting from scratch essentially. And you have to show the least variance required for any changes. And it makes sense on a public policy level. You have a brand new lot. You're starting from scratch. You're knocking everything down, right? That's why the code is clear about nonconformity may remain, notwithstanding those nonconformities as they exist. However, when you change it, all bets are off. You gotta comply with the code as redrafted and readopted in 2012, 2014, so on and so forth. So that's my final comment on that.
Right. Is there any questions from the board? So, Hillary, what I think we'll do with this is we're not back for 2 weeks. Am I correct?
Yes, that is correct.
So why don't we, not this next Wednesday, the following Wednesday, we'll look at this at executive session. And I don't need a giant thing, but maybe a memo from each person on what their points are, short memo on each points, and we'll vote on it. What's the date of that?
That's June 3rd.
June 3rd, we'll vote on this. Okay? Harry?
Thank you.
Okay. Thank you. Thank you, all three of
Thank
you.
you.
I appreciate it.
Thank you.
Okay, so.
Thank you.
We have one more case left. We're a little bit ahead. We're going to take a 5-minute break.
Thank you.
Sean,
I was
you
going to
can-
ask for that.
Yeah.
Well, okay, I'm not sure about the city witness. It looks like they are.
Sure. Why don't we take a 5-minute break? Everybody get a little water. Sean, you can start setting up, right? And then we'll be right back.
Great,
Okay.
thank you.
Derek, I just wanted to let you know I'm here. I've been here for,
Oh, there you go. Oh, you landed.
I landed and I signed in while they were talking. So I just.
All right, that's great. Thank you so much.
You're welcome.
So number 7, MI 2026 000272 118 Hillside Avenue. Attorney is Dawn Tangradi, Sean Whalen, and Leonard Reuter are involved. An appeal against L&I. Let's start with Dawn.
Dawn Grady will be coming in as a
Sure,
panelist.
thank you.
Good morning.
Good morning, Dawn. Could you please state your name and spell it for the stenographer?
Sure. Dawn Tancredi. It's DAWN. Last name is TANCREDI.
Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes.
Mr. Whalen, could you please state your name and spell it for the stenographer?
Certainly. Good morning. Sean Whalen, WHALEN, here for the owner of 118 Hillcrest Avenue, CAMA Plan Administrator, FBO, Christopher Blatney.
All right. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes, I do.
And Leonard, just for the record, state your name. You've already been sworn.
Thank you. May it please the board. Leonard F. Reuter, REUTER, Senior Attorney, City of Philadelphia.
So we'll go with opening statements first from all three.
Yes, if everyone could just give a brief, like
Yeah.
within 5 minutes statement of
That's right.
your
Right.
case, where you're going, that would
Yep.
be helpful.
And,
Thank you.
Dawn, why don't we start with you?
Okay, great. Good morning. My name is Dawn Tancredi, and I represent Mark and Laura Dinkfield, who live at 99 East Bells Mill Road. Their property abuts 118 Hillcrest Avenue, the subject of this appeal. The owner of the property is CAMA Plan for the benefit of Christopher Blatney. We are here today challenging the issuance of permit number ZP 2021-013581, which was issued on August 26th of 2022 for the new construction of a detached building with roof deck for use as a single-family home with a 3-car garage and an additional accessory surface parking space on the property located at 118 Hillcrest Avenue. The permit was issued in error and violates the Wissahickon watershed overlay. We previously appeared before this board under calendar number 2022-006535. After 3 years of appeals regarding the timeliness of neighbors' appeal, this case has been remanded to be decided on the merits. As such, I would ask that the 2022 calendar number be consolidated with this calendar number, as this is the same case. I've turned in a packet of information and exhibits, which I ask be incorporated into the record. The issue in this case is the starting point for measuring a 200-foot setback for development proposed within the Wissahickon Watershed Overlay District. The evidence shows the question was already answered by this board in 2015 and subsequently affirmed by the Philadelphia Court of Common Pleas and the Pennsylvania Commonwealth Court. The The starting point for measuring the 200-foot setback in this case is the outfall where a stream is physically located, less than 200 feet away from the subject property. The outfall sits across the street from 118 Hillcrest Avenue, just inside the fence on the Morris Arboretum's property. The stream is in fact shown on City Planning's map in their offices. However, the city's map is inaccurate. There is a mistake as to the location of the stream on the map in the City Planning office. The city has failed to maintain the map as required by the ordinance. The city has failed to maintain the maps for operational productivity and validity. To uphold the permit here for the development that has been issued based on a faulty map when it is clear that the map is wrong and that an outfall lies within 200 feet of the property is absurd. The Wissahickon Watershed Ordinance precludes development within 200 feet of the outfall. The overlay is there to achieve environmentally sound land development. It's there to protect the watercourses, vegetation, and animal life. Allowing the development at this location goes against the spirit and intent of the code and is a direct contradiction of the Wissahickon Watershed Overlay District. The city has been on notice that the map is erroneous and has done nothing to correct it or ensure its accuracy. The owner also is well aware that the property sits in the watershed district. There has been no development on this site. There have been some revisions to the overlay over the last several years. For example, there's been a changed definition of impervious ground coverage. However, regardless of any of the changes to the overlay over the last several years, the neighbors assert that the proposed development falls within the 200-foot radius where no development is permitted. Thank you.
Leonard, why don't we have you opening
Okay.
next?
The city's position here is that, I mean, in certain aspects, we don't disagree with some of what Ms. Tancredi has already presented. The Wissahickon Watershed Overlay restricts the creation of any structures that use impervious surfaces within 200 feet or 50 feet, depending of a swale or a stream. However, that is based upon a map that is, again, maintained and kept by city planning and is made available to the public. So unlike every other overlay district, which just has boundaries and has a boundary map that's attached as an exhibit to the ordinance and shows up in the actual code, the Wissahickon Watershed Overlay makes reference to a specific map that's a physical map. And just for demonstrative purposes, we actually brought a copy of the map here today so everybody can see that we'll have testimony that there is in fact a physical map, and that's what we use. With respect to the particular feature at issue, which is known as the Morris Arboretum Creek, the question is whether whether the entrance to the portions of the creek are in a culvert. If it's in an enclosed culvert, it doesn't count for purposes of the distance separation requirements in the WWO, which is Wissahickon Watershed Overlay. So the question is whether the structure in question here is within 200 feet of that entrance. So according to the physical map, it is not, and again, I think we didn't reach a stipulation, but I think it's uncontested that on the map, it is not the impervious portion of the structure in question is not within the 200 feet. We recognize that the map has an inaccuracy with respect particularly to the Morris Arboretum Creek because that creek apparently had been altered by University of Pennsylvania, which operates the Morris Arboretum, sometime in between the late 1970s, probably in the 1980s. We're not sure when it happened. And the reason, by the way, we don't know when it happened is because they never had any permits to do that work. But that's beside the point. The problem is that we recognize that there is a discrepancy. However, the code requires us to rely on a map, and what the board can't do is grant equitable relief. The board has to follow what the code says. The code says that the city has to rely upon a map, which is a physical map. And yes, that map has not been updated, but the board can't force the city to update its map, and the city can't be in a position where the burden is on the city to make a determination of whether exactly a particular impervious feature is or is not within the 200-foot buffer zone, because that would require the city to bring in geoengineers and do all sorts of other things which are well beyond what the requirements are of the code. Should the provision of the code be rewritten? Possibly. Could the map be updated? Possibly, although that requires not just simply, again, it wouldn't be simply the city will just say adopt somebody else's topographic map. The city itself would be obligated to go out and spend probably upwards of millions of dollars to do a full LiDAR type of survey of the Wissahickon watershed. So again, it's not it could be done, but not without inconsiderable expense that would have to be approved by council, most likely. And also, again, is beyond the purview of the board to require that. What the code requires is that the city uses a map. The only map that we have that meets the description of the map that we're required to use is the impervious surfaces map, which we know colloquially as the streams and swales map, which we brought here today. And that's it. So unfortunately, we agree that there's inaccuracies, but again, the code essentially requires us to use that. If the code needs to be changed, that's for city council to address.
Sean?
Yes, thank you. In brief, I think I agree mostly with what Leonard described here, and I would recharacterize the case because I think from a legal context perspective, that this is an appeal against L&I really sets forth the futility of this appeal. And I think it is a legal futility as I'll outline. So, sorry, can everybody hear me now?
Yeah.
So as framed by Ms. Tancredi about a proof between whether a map is or is not correct or incorrect, that's not this case. That's not, that's for a judge's determination in a plaintiff and defendant type of case. Legally, we are in the context where, as Ms. Tancredi admitted already, this is an appeal against L&I. There was an issued permit. There's a legal presumption that everyone at L&I and within the city did all of their municipal functions in the proper way, in the right timing, as they should have. And here they did. They walked through the code as Leonard just said, and when that happens, that's a conclusive presumption. And then when that presumption becomes conclusive, this board has to give substantial deference to the determination by L&I. So here, there's no discussion that L&I did anything wrong. They followed every step of the code. And what Ms. Tancredi's clients are saying is, well, then they relied on the wrong map. Well, that, again, is either a legislative relief that they're seeking or an equitable relief. That's not, neither of which this board can grant. So even if we assume, for the purposes of argument, that the map is incorrect, the code requires that Planning Commission establish a impervious coverage map. There's no further definition of it. It's an identified code, identified name in the code, and then Planning Commission is left to determine what map that is. They've been using the 1973 map, again, the streams and swales map that you just heard. However, there is no requirement in any code that the planning commission update that map routinely, go out and double check that map. And so what happens when you have an applicant like mine, they submit a building permit application, and you'll see from the approved plans, they, as part of the analysis of submitting their plans, they get told by the planning commission where the line is of 200 feet. And what you'll see in the approved plans as we go forward is that that line of 200 feet actually extends into the 118 Hillcrest property, as said by planning commission, but it only covers a portion of the driveway. But in the driveway, there was an allowance for pervious pavers because the code says basically if you go to the water department and the water department approves your building materials as pervious, then that doesn't count towards against the impervious coverage. So here, what happened was my client, my applicant, took all the steps appropriate as set forth by the code. L&I and the city then acted in all ways appropriate under the code. And in the end, because this is an appeal against L&I, there can be no showing that L&I did anything wrong or acted in any kind of bad faith. So at best, we get to a place where this board has to issue equitable relief to say the code, we, the board, read into the code a requirement that the applicant now has an affirmative duty to submit a survey, which they do not as of now, or that the code should be different. In both of those instances, regardless of where you even come out, there is created an ambiguity in the code. And as we all know, any ambiguity in the code or the reading of the code requires a finding in favor of the applicant and the owner, which again here, they acted at all times properly, the city acted at all times properly, and now there's just a question of this underlying map, whether there is or is not an error there. And again, as Mr. Reuter laid out very well, that's a question for city council and a determination there.
Okay, thank you. Council, Dawn, I understand you have several people you want to call.
I do, and
Okay.
I would just like to briefly respond
Okay, all right.
to point out that besides requiring the city to use the city map, the statute also requires the city to maintain that map. So that's at issue here as well today.
Okay. Who's your first witness?
Okay, I would call Keith Davis
Okay.
from City Planning.
Mr. Davis.
I see no one in the audience with their name, Chair.
He's here.
Can you hear me?
We can, sir. Could you please state your name and spell it for the stenographer?
Sure. Keith Davis, Keith Davis.
Right. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Council, please proceed.
Thank you. Good morning, Mr. Davis.
Good morning, Tom.
Could you please describe your current role and responsibilities with the city?
Sure. I work for the City Planning Commission in the Development Review Division. I review zoning permits for consistency with the code. That includes zoning permits within Wissahickon.
Okay, great. Have you reviewed other zoning permit applications in the Wissahickon overlay district?
I have.
Okay, and how long have you been working with the city in this area?
Since I think 2015.
Okay, and how many applications would you say that you've reviewed in the Wissahickon overlay district?
So I haven't reviewed any in the last, I would say 4 or 5 years because we had a redivision of work. But prior to then, maybe between 20 and 30.
Did you review the plans for 118 Hillcrest?
I did.
Do you have a copy of the approved plan? I haven't received a full copy with the city planning stamp. Do you have that with you?
I
What, Leonard?
Yeah, if
don't.
I can interject here, Ms. Tangredi reached out to me earlier about that. My understanding is that the way things are done now with Eclipse, there's processes and different applications get reviewed by for prerequisite reviews by different things. The final permit and plan that are issued by L&I in this, with respect to this, for instance, won't necessarily have the planning stamp. The plan that is actually quote unquote stamped by city planning, which is really just an electronic thing, would be kept by planning. We didn't produce it because we weren't asked to. It was not part of the actual final permit that was issued, but, and I don't know if Mr. Davis has access to that through his system, but, we can provide it. I think the question is, whether Mr. Davis did in fact approve the plan. And I don't think there's any dispute about that. If we have to have a copy of a plan that got the planning stamp, we'll try to locate it, but that's not part of the L&I record.
Okay, thank you. Mr. Davis, you did in fact review this plan and approve it?
Yes.
Okay. All right. Let me just take you back for a moment to the Wissahickon Watershed Overlay District. Are you familiar with its purpose?
Yes.
And what is that purpose?
To protect the beauty of the Wissahickon by helping to preserve its streams and swales from erosion.
Is your understanding that there's more to it than the fact that it's only there to protect beauty? Is it there to protect vegetation as well?
So the 1973 study that was referred to actually gets into that, and the Wissahickon Valley in Philadelphia is a very small percentage of the Wissahickon Creek itself. So if the regulations were created to protect the water quality, for example, it wouldn't really have that big of an impact because, again, I think that the valley makes up only like 10% of the watershed. So the regulations that came out of this study actually attempted to meet a higher sort of purpose, which was the aesthetic quality, because they felt that by addressing the aesthetic quality, you would have a better impact on the water long term. So that was sort of the highest goal.
May I share my screen?
Yes.
Yes.
Oh.
It's coming up.
Okay, so do you see the plan on the screen?
Yes.
And is this the plan that was approved by the licenses and inspections?
I thought the driveway was on the other side. I wonder if there had been changes since
It could be because
I reviewed it.
Okay.
Yeah, it's possible that they changed their plan since we reviewed it, and it didn't trigger Planning Commission's review. But I seem to recall the driveway. Wait, this is 118?
Correct.
Yeah, it's hard to say. I thought the driveway was oriented to the other side.
Okay. I do want to take you back to the watershed overlay district. You mentioned the guidelines. Are you referring to the Planning Commission's Wissahickon Watershed Development Guide?
I was actually referring to the original 1973 study, which predated this, what you're showing here. This was a product of the study.
Okay, and this product of the study, are you familiar with this Wissahickon Waters Development Guide?
Yes.
Okay. Do you review it before you or during review of an application?
Not necessarily.
Okay. And 118 Hillcrest Avenue does fall entirely within the Wissahickon Overlay District, correct?
Yes.
Okay, if I can take you to page 7 of this guide, and this is number 14, tab number 14 in the documents that we submitted. The guide does indicate that there are required setbacks from watercourses, correct, on page 7?
I'm sorry, I have to object to the introduction of this document, or at least would ask for an offer of proof regarding it. This is not part of the ordinance. This is a document that was created in the 1970s. It's, I think, used as a general guideline by people in planning occasionally, and sometimes by property owners or applicants, but it has no official status that I'm aware of. It is not the code. The code has the requirements are set forth in the code. So I don't know why we're referring to this.
Dawn?
These guidelines were the basis for the Wissahickon overlay, and these were promulgated by the City of Philadelphia and by the City Planning Office, as indicated in the beginning of the guidelines. The witness has indicated that he's familiar with them, and my questions are related to if he's familiar with the reference to the purpose of the overlay, and in particular in reference to the environmental controls and the moratorium on development, which I would point out on another page 15.
Again, same objection. You know, the city publishes all kinds of guides, pamphlets, brochures, all kinds of things. The fact that the city produced it at a certain time and place doesn't make it. I mean, yeah, you could argue it's a public document, it's an official document, but again, this isn't what guides the approvals of permit applications in the watershed. What guides permit applications in the watershed is 14-510 of the code.
Sean?
Certainly, I would wage a second objection here in that to the extent that this document has any relevance, I believe Ms. Tancredi is suggesting that it has relevance as sort of a legislative background or a pillar of what the code became. As a matter of statutory construction, the board has to review the plain language of the zoning code. It doesn't bring in any other documentation or legislation or anything like that. It has to review the plain language. If the board then determines that there is an ambiguity in that language, then the board has the ability to go to legislative history and other documentation. But that is beside the point, and the board never does that, because if there's an ambiguity in the actual language of the code, then the determination is over and you have to rule in favor of the applicant and the owner. And so all of this documentation becomes entirely irrelevant if it's not included in the plain language of the statute.
Dawn, do you have a short response to that?
I do. There's other, the statute itself does address the purpose of the overlay. I would also just point out that this document does reference an agreement between the city and Commonwealth establishing the study of the watershed and a moratorium on development. And I would refer to this to further ask the question as to whether the city conferred with the Commonwealth at all regarding this approval of this plan.
So for this point, I agree with the both of them, Dawn, and I wish you, if we could move on.
Okay.
Thank you.
And Mr. Davis, are you also familiar with the Wissahickon Watershed Development Regulations from 1976?
The
city will just
maybe.
preserve the same objection. This is.
I would just like to ask the question whether it was.
My understanding, and again, unless Ms. Tancredi has information to otherwise, these regulations were not included and are not included in the current regulations of the City Planning Commission or the Department of Planning and Development, all of which the Department of Planning and Development didn't even exist when this document was written. And so again, unless there's some proof that these so-called regulations are in fact current regulations of the City of Philadelphia, again, we would object to their being presented at all.
Well, I would ask Mr. Davis.
To
I would ask Mr. Davis whether this regulation was ever repealed.
Sorry, you asked me if I was familiar with the 1976 regulation. I'm familiar with regulations, but I can't connect a date to them necessarily.
Okay. And the regulations, which I have here on the screen in front of us, which is found at tab number 15 in the materials that were submitted, page 1 of the regulations do describe an agreement between the city and Commonwealth establishing a study of the watershed and a moratorium on development. Isn't that correct?
Chairman, I would object, again, the same issue. There's a very obvious issue here, which is what does the code say? We have the code. We haven't even addressed the code. The code, as Ms. Tancredi said, the code actually includes the purpose. So even if she wants to get to the purpose, she can, but this is irrelevant.
So Dawn, I do agree with that.
All right. I would just note for the record that these are Wissahickon Watershed Development Regulations and that there's no evidence that they are no longer in effect. So I would just note that I believe that I should be able to ask about these, and with your comments, I will move on.
Right. Thank you very much.
So, Mr. Davis, I will pull up a copy of the plan. And the document that I'm showing everyone was provided by your attorney, by the city's attorney. Could you tell us what you did to review this application and how you determined whether or not the plan should be approved?
Sure. So I created this map. The underlying map in crayon, the yellow background with the black outline stream there. That is taken from the larger streams and swales map, which I believe is in the room today. So I geo-referenced that map so that we could compare it with other digital layers. And I did the same for the development plan there. So that's the plan that I was familiar with, which I believe shows the driveway on the opposite side. So that was the plan that we reviewed. So what I did was I included the development proposal with the streams and swales map with, and then the other sort of blue line there, that is the hydrology layer from the water department. So that's more reflective of the existing conditions. So it kind of lined those three layers together to do the analysis to well, first see that there was a difference between the 200-foot buffer. So the green circle represents a 200-foot buffer from what's, I guess, more reflective of existing conditions. So that intersection there is where the walled stream goes underground into a culvert that goes under, is it Hillcrest or Hillview?
Hillcrest
So
Avenue.
yeah, so that would be the 200-foot buffer, and you can see that it intersects with the development with the building itself. And then the other circle represents a 200-foot buffer from the point at which the stream goes into the culvert in the overlay maps that the code instructs us to look at. So there you see that pink circle represents a 200-foot buffer from there, and you can see that part of the driveway is part of the driveway falls within the 200-foot buffer, but none of the building itself. So yeah, so we encountered the question of whether to use the 200-foot buffer from the existing conditions or from the streams and swales overlay map. So that's what we're looking at.
And are you familiar with the history of these properties and the fact that city planning in the past did use the outfall as a starting point to measure the 200 feet?
I am not. Not for this site, or I don't know if I've worked on any other examples in the Wissahickon where that was specifically the point of measurement.
I do want to show you the approved plan here, which is stamped, and Leonard and Sean, would you stipulate that this is the approved plan for this
Yes,
matter?
I'll stipulate that that is the plan that was ultimately approved and part of the permit that was issued.
Okay,
Stipulate
and
as well.
okay, and Mr. Davis, the map that you prepared, would you agree that the driveway is in a different location on the approved plan compared to the plan that you reviewed here and measured?
Yes.
Okay. So it appears that you did not measure the 200 feet with the correct plan because you stated this is the plan that you used to track your measurements.
It's likely that they amended their plan, and unless one of my colleagues reviewed the final plan, Elle and I might have had enough information that they didn't need to return the plan to Planning Commission for our review. So I think that we had kind of addressed the issue, whether the driveway was on the right or the left. It was really a matter of where which circle we were using for our 200-foot buffer. And also there's a lot of discussion with Water Department about making sure that the driveway pavers were approved.
And if you focus on the, I'll call pink 200-foot buffer that you said that you focused on, if you look at that pink arc in the map that you prepared, would you agree that that arc does not touch the edge of the, I'll call it the edge of the driveway?
It does touch the driveway. It touches probably the first 20 feet. The pink circle?
Yes.
Yeah, the pink circle touches, so that's yeah, they have the driveway curb cut labeled there. So yeah, it touches, so it's the first 20 feet of driveway.
Okay, but it does not touch the driveway at the driveway closer to the house, correct? Whereas to compare to the plans that were submitted, I'm showing you the approved plans that were submitted. These plans also show an arc, correct?
Yes.
And that arc touches the corner of I'll call it the driveway area, the paved driveway, the porous driveway, correct?
Yes.
Okay, so the approved plan shows a different arc than,
Oh, no. When you say arc, you're referring to the arc of the 200-foot buffer?
I'm referring to the arc of the 200-foot buffer on the approved plan that was submitted.
Yeah, I don't know that the arc is different, but the driveway is different. So there's going to be more driveway within the arc because the driveway is now shifted to the building's right. I
Okay.
don't know that the arc has changed, but there's definitely more driveway involved, and I think it's because the driveway shifted.
Okay, and this is the approved plan, correct?
Yeah, it
Okay.
looks like it.
Okay, all right. So the arc on the plan that you submitted, that your attorney has submitted for this case today, shows a different arc than what's on the approved plan.
That's not
I
what he
don't think so.
testified.
No, I think it's the same arc, different driveway, but it's hard to tell without, a ruler. But yeah, I don't know that the arc has changed.
Okay, you testified that you prepared this map, correct?
Yes.
Okay. All right. And you agree that the blue line on this map is the actual physical conditions of the stream, correct?
That blue line is from the water department's hydrology layer. So to the extent that that is consistent with the existing conditions. And it's not always, because the nature of rivers is that they move. But that is, I would say it's more representative of existing conditions than the streams and swale map.
Is the hydrology map based on GPS? Do you know?
I really don't know.
But you believe that it's more actual. It represents the physical conditions.
Just from my experience comparing it to aerial imagery, it is more consistent.
Okay, and you prepared this map. You added the green arc, which would show the 200-foot buffer from the existing conditions, correct?
I try to draw that point as close to the where I could tell that the outfall was from the aerial imagery.
And within the 200 feet, using the green arc, there's impervious coverage on this map, correct? On this plan, correct?
Yeah, well, the street itself, and then proposed, yes, the building and the driveway.
Do you know if the city planning office, do you know what the city planning office does to maintain the map in their office?
Well, we protect it and make it available. But it's behind the map itself. I mean, I guess it's there today. It traveled to the ZBA today. But the map itself is laminated, so there's no changing the physical map. Like I said before, I scanned it and georeferenced it, which means I put it on another map in order to preserve it. So I would say we're preserving the map and making it available.
And what I'm showing here, which is marked as Exhibit 10, is this what the map looks like?
Yeah, I don't know what's happening on the bottom left there, but that's looks like a camera mistake. But yeah, that is the map.
And is this map accurate?
I think the question, well, it's accurate in that I mean, I can't tell because I don't know what the orientation of the creek was in 1973, or 1972 or 73, which is when this was made. But is it consistent with existing conditions? I don't think so.
Do you have any evidence that the stream here has been moved?
Objection. What's being shown on the screen hasn't been identified. I think the city will concede that it looks a lot like the map, but we don't know what section of the map this is showing, so I don't see how he could possibly answer that question.
Okay, Mr. Davis, from your review of this plan and the city's streams and swales map, do you believe that this is the Morris Arboretum Creek in front of you?
Yeah, I recognize that section.
Okay. And do you have any information to show that the stream was moved since 1973?
Well, so in addition to the streams, you also have the street layer. So you can make out Hillcrest, which runs between the two creeks. And then you also see the contours of the land. I'm not entirely sure how they created the contours back then, but the fact that the stream to the left of Hillcrest follows the contours, but now it doesn't. So now, like I would say, like the last, I mean, it's hard to scale this, but like the last 100 feet of that creek makes a hard jog down towards Hillcrest, which is against the contours, which leads me to suspect that it was moved probably during street work. So I suspect it was moved, but there's, this is definitely different than the water department's hydrology map in regards to the last 100 feet of the creek. But I mean,
So
I
you don't really
I don't
know,
know.
or you don't have any information that it's moved.
I haven't seen any permits.
And you don't have any pictures showing that it's moved either, correct?
The aerial photography dating back to then is less reliable than it is today. But I did a hard search for permits and for pictures of the creek to see if it had been moved.
And you did not find any?
No.
So in 2015, the zoning board issued a decision stating that the outfall was to be used for the starting point of the 200-foot setback. Later, the Philadelphia Court of Common Pleas upheld that decision, agreeing that the outfall should be used as the 200-foot setback. And again, Commonwealth Court agreed that the outfall should be used as the 200-foot setback. Is there a reason why now city planning has disregarded all three of those
Objection.
decisions and used this map to start
Objection.
the
She-
Why
first-
don't we,
measurement?
Leonard,
making an ass-
please respond.
Yeah, objection. First of all, she's making a statement with respect to the law and asking the city witness, who's not an attorney, to comment on, first of all, whether or not her characterization of the decisions is accurate, B, asking him to offer an opinion regarding that, her statement of the law. So the city would say that she can't ask the question. It's not, he's
I'll
not here
ask
to
another question. Mr. Davis, how did you determine the starting point in the review of this case for the 200-foot setback?
How did I determine that we would use this study, this map starting point?
Yes.
Because the code tells us to. So outside of the Wissahickon, there's also I think 50-foot boundaries, which tell us to use the water department's hydrology map to identify the creeks and streams and rivers that that section of the code applies to. So by extension, for the Wissahickon, it tells us to use the Wissahickon map overlay. So that's what I do in the Wissahickon.
Okay. And I do want to show you, which will be submitted. It's part of the documents at tab number 6. This is a report that we will have an expert available to discuss. I want to point out some photos in the report. Have you had a chance to review this report by any chance? From
Briefly.
Shandor Saleh? You have, okay. So are you familiar then with the photos that are part of this report?
Yeah, from this report.
And I'm showing you what
I would object as the foundation. I mean, we're getting told that it's a report. We don't know with regard to what address. I saw a name, Dingfield. That name isn't involved in this. Hasn't been identified here.
I'm sorry, Mr. Whalen. This is the reporter. I apologize. I just cannot hear you.
Oh, sorry about that. Is that better?
Yes, sir.
I apologize.
Okay, I'll explain. So I'm referring to tab number 6, which is a report prepared by Shandor Saleh. And the purpose of me showing the report at this moment is to point out a couple of the photos. I know, Mr. Davis, you said that you were unable to find aerial photos, but you did say that you did review the report of Mr. Saleh?
Yes.
And does the report show aerial photos from 1959 of this subject area that we're talking about today?
Yeah, and I was surprised to see that we do have aerials from DVRPC, for Delaware Valley Regional Planning Commission, from 1970 and 1975, which I would have assumed would be better quality and more closely related to the study itself. And I couldn't tell from those aerials, so I was surprised to see a 1959 aerial that was so was so clear, but this is not available to us.
Okay. And if you can you tell if this aerial shows the stream in its current location?
I'd really be going out on a
object to
limb.
this whole line of questioning. Again, the issue is what the code requires. The issue is not what does a photograph from 1959 show. The city has, I don't know how much longer we need to belabor the point. The city has conceded that the map doesn't show the current topography or location of the Morris Creek, the Morris Arboretum Creek. So I don't know how many times we have to go over the same exact ground in 50 different ways. And again, having the witness testify to what a 1959 photo shows, which has no measurements, no other topographical features that are identified, I just don't see what the point of any of this is.
Dawn.
Okay, I will move on. And I will just bring up the section of the code. So so we're all clear, Mr. Davis, would you agree that section 14.5.10 is the Wissahickon Watershed Overlay District, overlay district?
Yes.
And this section of the code discusses the setbacks from watercourses, correct?
Yes.
And under section 5A, the code states there shall be no new impervious ground cover constructed or erected within 200 feet of the bank of a stream or within 50 feet of the center line of a swale within the overlay district. Is that correct?
Yes.
And would you agree that the physical conditions do show the bank of a stream within 200 feet of the development here?
Yes.
Okay. I have no further questions.
I just have a couple quick follow-up questions. If I could share my screen.
Sure.
Hopefully I can
I'll
do that.
stop sharing.
Thank you. Where's the share screen thing? I should, oh, wait a minute. Am I not? Sorry, I have to log. This will just take me a moment. I don't believe. I should be logged into the Zoom. Am I not logged into the Zoom?
Is Leonard logged in?
I see you.
As a panelist?
Yeah,
No,
well-
you can see me in the main Zoom channel. I don't know if I'm in the audience or not.
It disappeared.
I should be because I'm looking at the Zoom. There we go. Now I'm being upgraded. Everything's fine.
Okay.
Oh, neat. There we go. All right. Thank you. Can everybody see my screen? I can see it.
You can.
Okay.
Yes.
Regulations of the City Planning Commission.
Thank you. Keith, can you confirm these are this looks like a copy of the regulations of the City Planning Commission?
It does.
I
Yes.
would just ask or confirm, Mr. Reuter, this document was not sent to me in advance, correct? Is this a
That's
new
correct.
document?
Yeah, these are regulations of the City Planning Commission that the board can take judicial notice of, but we'll confirm. And again, this is for rebuttal purposes because you had made statements regarding regulations, so we wouldn't had to have produced it. I wasn't planning on it, but now I am. Mr. Davis, can you confirm that this looks like a copy of the regulations of the City Planning Commission?
Yes.
Great. And just on the notes on the cover page, does it say when these were promulgated?
Yes.
And when was that?
April 20th, 2012.
Okay, and you can see it's also been amended many times since then?
Yes.
Okay. And I'm going to draw your attention to another section. Section 1.2. Could you read 1.2 of the regulations?
Prior regulations superseded. All regulations heretofore adopted by the City Planning Commission are hereby superseded.
Thank you. Now, with respect to the issue of, now just for a little bit of background, you say you've been working for planning since 2015?
I've been working in this capacity since 2015.
Okay, and so in 2015 and prior to that, you were working for the Planning Commission, the Philadelphia City Planning Commission, is that right?
Yes.
Okay, and in 2016, the City Planning Commission became absorbed as a departmental board of the newly created Department of Planning and Development, is that right?
Yes.
Okay. Sorry. All right, so, and at the time, the prior guidelines and other documents that were presented by Ms. Tancredi, at the time those things were produced, they were for the City Planning Commission, which was an independent agency, is that right?
I wish I can't say for sure.
Well, you weren't part of the Department of Planning and Development because that
Oh,
didn't
right.
exist, right?
That's
Okay.
right. Yes.
Okay. So now with respect, and again, you have testified that while you're familiar with the existence of the documents, you're not aware that there's any requirement that those documents have any kind of binding authority, do they?
Guidelines. I had mentioned that I have them and I'm familiar with them and I look at them, and that's really just to get a better understanding of where our regulations came from.
Okay. And so again, just so we're clear, the code with respect to reviewing a permit application that for new construction or any construction in the Wissahickon watershed, you look to 14510 of the Philadelphia Code?
Right. Yes.
Okay. All right. And that language in the code takes precedent over anything else that you're aware of?
Yes.
Okay. I don't have any further questions.
Sean?
Yes, thank you, Chairman. I can be very quick. Good afternoon, Mr. Davis. I can't see you anymore, but I assume you're still there.
Good afternoon as well.
Sorry. Very quickly for you. So you said that you reviewed approximately 20 to 30 applications regarding Hillcrest Avenue, correct?
Oh, no. I think the question was, how many have I reviewed in the Wissahickon?
Oh, in the Wissahickon. I apologize. I misstated. So let me restate. You said you reviewed 20 to 30 applications in the WWO, correct?
Yes, probably more, but that's, yeah.
Thank you. And did you follow the same review procedure for all of those applications?
This was definitely unique. But I guess as far as, referring to the code and being guided by the code, yes. But other there are other regulations in the Wissahickon, like steep slopes, for example, that would require slightly different process, or I would need different different information from the applicant. But as far as the 200-foot and 50-foot swale and stream buffers, yes.
Understood. So your review in any application is guided by what the code requires, correct?
Yes.
And Ms. Tancredi, if you wouldn't mind, I think you called it Exhibit 10. It was the map with the green circle and the magenta circle. I couldn't get it to render on my screen. If you wouldn't mind putting that up for me. think it was, yeah, perfect. Thank you. Mr. Davis, this is the map that you looked at with Ms. Tancredi. Now, with regard to the green circle and the magenta circle, Ms. Tancredi had you describe what proposed potential new development would be within that circle, correct?
Yes.
But now you stated that the approved plans that were showed by Ms. Tancredi, and we can go to those if you need to see them again, appeared to be revised from what is being shown as proposed on this map, correct?
Yes.
Okay, so what would be proposed development in this map and therefore included in one of those two circles might not be the same as what is proposed in or what is proposed by the approved plan, correct? Because it's a different plan.
So can you restate that?
So sort of as you described that the driveway changed, but the circle did not change. What I'm trying to make clear is that here, while the circles remain unchanged, the building itself as approved changed from what is shown on this map screen, correct?
I wasn't focused on the building. I'm not sure if the building, I mean, I guess it probably did because the garage would have moved too, but I don't recall if the building changed. I just noticed the driveway.
Okay. Now, Mr. Davis, did you visit the site?
I drove by it.
Okay. You didn't get out and walk around it or walk over on the Arboretum side?
No.
Okay. Are you personally trained as a hydrologist?
No.
Okay. And the last thing I would ask, Ms. Tancredi, I could pull it up if you want, but do you have the approved plan right there? I just have one more question for Mr. Davis. Thank you. Mr. Davis, do you see in the bottom left of that screen, it says proposed 200-foot watercourse setback based upon mapping provided by City of Philadelphia Planning Department?
Yes.
Okay. Do you have any reason to believe that that does not match the information that was provided to the applicant in this case?
No, I don't. I don't know why they call it proposed, but no, it looks to line up with what I shared.
Okay. And I understand you mentioned briefly with regard to a lot of back and forth with the water department. Was that with regard to the approval of pervious pavers?
Yes.
Okay.
And
so,
yeah.
So there is, as shown in this approved plan, new development that would be within the 200-foot setback as shown on the plan, correct?
Yes.
And it's your understanding that new development that's inside of that circle was approved by the water department?
Yes.
Thank you very much, Mr. Davis. I have nothing further.
Okay.
Thanks.
All right. Dawn? Could you, you're muted. You're muted, Dawn. Dawn, you're muted.
Okay,
Yeah.
okay, sorry
Correct.
about that.
All right.
Okay,
So
Mr. Davis, oh, may I
Well,
briefly?
hold on 1 minute. How much more time do you need, Dawn? Because we're ready to break.
Okay, a couple questions.
How long?
I would say I have a couple questions, but if the
No.
board would like to break, I
We're
understand.
Well, I think, go ahead. Try to get it
Okay.
in.
Okay, Mr. Davis, the bank of the stream is not shown on your map, correct? You're muted.
Sorry, that's correct.
And the purpose of the map is to show which streams are included in the regulations, correct?
Yes.
And the measurement is from the bank of the stream, correct?
Yes.
But you mentioned the bank of the stream is not shown on this plan, correct?
Yes, but it's our understanding that the streams were walled. So the bank would be since these are polygons and not lines, the bank would be the edge of the stream.
And one more question. The spirit of the regulation is to protect the stream, correct? Not this piece of paper in the city's office?
Yes.
I have no further questions, Mr. Chair.
Okay. So Dawn, give me an idea how many more witnesses you have in the future, so for planning purposes.
Sure, I would estimate 3 more. I've got a surveyor, Mr. Jim Henry. I've got Mr. Shandor Zalale, and I may have 1 or 2 others.
Okay, so this case is going to be continued 7/28/26 at 9:30 a.m. And thank you to all 3 people. I appreciate your time.
Thank you.
Thank you. Maybe.
Thank you.
Thank you very much, Board.
What?
Is there anyone left whose case has not been called? No.
I see no hands, Chair.
Thank you. Thanks, everybody. See you all tomorrow.
Thank you.